Right. Good morning to everybody, or good whatever part of the day it happens to be in, wherever you are. I think we've got quite a lot of people attending, and this is one of the marginal advantages of the Zoom era, that we can go global with our seminars. My name is Andrew Harding. I'm with the Center for Asian Legal Studies, which is your host today for this viral seminar, this virtual roundtable, as we call it, which is in effect a book panel, and we're going to discuss Richard Albert's now, I think, very well-known book on constitutional amendments. I must say I have enjoyed reading this book very much, and have been able to refer to it many times over the last few months. So it is our absolutely enormous pleasure and privilege to welcome the author of that book, Professor Richard Albert, who is, as I'm sure you all know, normally based at the University of Texas in Austin, although he tells us that the background that you can see is actually in his hometown, Ottawa. So we're spanning quite a number of time zones, and welcoming Richard, I also hope that it's not too horribly late in the day for you over there in Canada, but it's great to see you. And I want also to welcome our speakers today. We've got Virginie Kuoch, Sharowat, Shamin, Khemthong, Tonsakulrungruang, which is quite a mouthful, Khemthong, but anyway, it's great to see you here. The speakers are going to make some remarks about Richard's book. We'll first of all hear from Richard himself. Just by way of general introduction to the topic, I think it was Hans Kelsen, but Richard will correct me if I'm wrong, who says somewhere in his writings that the rule on constitutional amendments is the most important rule in any legal system. Which, well, if it wasn't Kelsen, it's certainly a very Kelsenian view of the world, but there is surely a lot of truth in that statement. So the making and breaking and shaping of constitutions by constitutional amendment is an extremely important topic, which I must say is one that has fascinated me for a very long time. And I know this discussion is going to fascinate you all as well. So thank you all for joining us. Thanks to the speakers, and especially to Richard for joining us. And I will now hand it over to Richard for his opening remarks. About 10 minutes, please, Richard. Thank you.
Well, thank you so very much. I want to thank NUS and the Center for Asian Legal Studies for hosting this roundtable discussion. I want to thank Professor Jacqueline Nao for her invitation to do this, and to Professor Harding for moderating this program. All of us send our greetings and good wishes to Professor Shah, who is currently recovering. We wish you a speedy recovery if you're there. And to the entire panel, an outstanding group of scholars that really honors me with their participation. And so thank you for being here, to the panelists, and to Saguna and Ernie and Ben and the entire team for putting on this event, and to all of you for being here. For those of you who've had a chance to read the book, thank you. And for those of you who have not yet read the book, perhaps I might say a few words about the ground I cover, so that we can have a conversation about the themes in the book, because I would very much appreciate hearing your views, either today in the context of this discussion, or later on by email, or even by Zoom if you'd wish to chat about these ideas, and also your own ideas about constitutional change. A constitution and procedures for its amendment are, to me, like a lock and key. One cannot work without the other. And so it should be no surprise that constitutional amendment rules appear in virtually every constitution in the world, because no part of a constitution is more important than the procedures that we use to change it. Amendment procedures reflect, in my view, the most fundamental, most important values of the Constitution. They open a window into the soul of the Constitution. exposing its deepest vulnerabilities and revealing its greatest strengths. Amendment procedures are, moreover, the gatekeepers to the Constitution. They give political actors a roadmap to alter the Constitution. They identify what is subject to or immune from change. And they encourage public deliberation on constitutional meaning. They, moreover, foster stability in making the Constitution harder to change than by regular legislation. And they also make it possible to achieve transformative constitutional reform without recourse to revolutionary means. And so at their core, amendment rules are just so important. They also reflect both faith and distrust in political actors, because while they authorize change to the Constitution, they limit how and when modifications are permissible. You might think of it like the Roman deity Janus, whose two faces point in opposite directions. Constitutional amendment procedures, likewise, are deployable for both good and evil. They may be used to strengthen or destroy the Constitution's institutions, to enhance or diminish constitutional rights, to accelerate or reverse progress on the mission that the Constitution sets for itself. In short, amendment rules may be used to build or break the very foundations that amendment procedures protect from ordinary change. And so we must pay close attention to how we design amendment procedures, because mistakes can lead to constitutional disaster. Given the importance of amendment rules to constitutionalism, to democracy, and to the rule of law, I wrote this book as a roadmap for navigating the intellectual universe of research into constitutional amendment, and also as a blueprint for building and improving the rules of constitutional change. And I begin the book by asking an essential question that arises from the fact that virtually all constitutions codify amendment rules. And the question is why? Why have amendment rules at all? I show that amendment rules have three categories of uses: formal uses, functional uses, and symbolic uses. Their formal uses include repairing imperfections in the Constitution, distinguishing ordinary from constitutional law, entrenching rules against easy repeal or revision, and establishing a predictable procedure for constitutional change. Their functional uses include checking the court, promoting democracy, heightening public awareness, pacifying change, and managing difference. And symbolically, amendment rules can be used to express constitutional values. I then turn to what I think is a provocative claim, which is that some constitutional amendments are not amendments at all. They are self-conscious efforts to repudiate the essential characteristics of the Constitution, to destroy its foundations. These kinds of changes dismantle the basic structure of the Constitution, while at the same time building a new foundation rooted in principles contrary to the old. And so I suggest that changes on this scale are not properly called constitutional amendments. They're better understood as constitutional dismemberments. A constitutional dismemberment is incompatible with the existing framework of the Constitution. As I seek to explain in the book, a constitutional dismemberment intends deliberately to disassemble one or more of the Constitution's elemental parts by altering a fundamental right, an important structural design, or a core aspect of the identity of the Constitution. And so, to use a rough shorthand, the purpose and effect of a constitutional dismemberment are the same, which is to unmake the Constitution. This raises a question, which is, well, what then is a constitutional amendment? And so I distinguish an amendment from a dismemberment by explaining that there are four fundamental features to an amendment: its subject, its authority, its scope, and its purpose. The most important feature of all is the scope. of the change. That's what really distinguishes an amendment from a dismemberment, because an amendment must at all times, not exceed the boundaries of the existing constitution in order to be properly called an amendment. The discussion of amendment leads us to a discussion of constitutional unamendability, because some constitutions include rules that prevent the amendment of the Constitution. I explain 7 reasons why constitutional designers choose this constitutional design. And in explaining these reasons, I discuss many examples from around the world of codified unamendability. But I also explain that unamendability can arise in 2 other forms that do not appear in writing in a constitutional text. First, interpretive unamendability. It emerges from a judicial decision or an unwritten constitutional norm rooted in the dialogic interactions of political actors. 2, unamendability can also be constructive unamendability that arises as a result of the practical impossibility of gathering the required majorities to amend a rule, despite that rule being freely amendable in theory. I then take a view from about 30,000 feet in the air to try to put all of this together, to explain the architecture of constitutional amendment rules. I examine the many options available to designers to build their own rules of change. I also weigh what I view to be the weaknesses and the strengths of these options, and I seek to offer some guidance when one choice may be better than another. And so, for example, I compare single track with multi-track pathways in constitutional amendment. I compare single subject and omnibus amendment bills, and I compare procedures for amendment and dismemberment of a constitution. I also explain and defend why unamendability, in my view, is problematic for democracy. And I suggest an alternative design that can achieve the expressive function of unamendability while not denying the fundamental right of amendment. Finally, in this particular part of the book, I examine what I think is an important relationship between time and change, namely how constitutional designers can use and manipulate time in their design of amendment rules. And I also explore the judicial review of constitutional amendments, beginning first by explaining 8 different strategies that a court can use to invalidate an amendment. And then I elaborate several alternatives to the judicial invalidation of constitutional amendments. I have to say that my favorite part of the book, if I may say so, concerns a question that constitutional designers rarely ever ask, which is, how will the Constitution indicate that it has been amended? How do we know? Will the change be recorded at the end of the original Constitution, or will it be inserted directly into the founding text or in some other way? And so in this part of the book, I offer what I found to be the first systematic analysis into the options available to constitutional designers for how they will codify amendments in a codified constitution. I identify and illustrate 3 major models of amendment codification in the world: the appendative model, which we see in the United States and many other countries; the integrative model, which we see in India and other countries; and the invisible model, which we see in Ireland and also in other countries. But I also have a discussion of how uncodified constitutions indicate that they've been amended. And this I call the disaggregative model, which we see in Great Britain, for example. What I try to really stress to readers in this part of the book is that the choice of how and where to memorialize changes to the Constitution, that involves more than mere aesthetics, because it entails implications for how courts will read the Constitution in the course of adjudication, for whether the Constitution will become a focal point of reference in constitutional politics, for how intensely the text will be venerated, if at all, and also for the nature of the relationship between citizens and their constitution. Because the way amendments are recorded in a text, let's say, that's ultimately a choice about how, and indeed whether, a people chooses to remember its past. And finally, the last major thing that I seek to do in the book is to anchor these ideas in a normative foundation. Because the practice of constitutional amendment as an activity in constitutional politics, that practice reflects democratic values, the democratic values of the rule of law, including predictability, transparency, and publicity. And so I explain why amendment is valuable to democratic societies, why that power should be exercised regularly, and how it helps to reinforce both constitutional democracy and also democratic constitutionalism. So that, in just a few moments, is most of the ground that I seek to cover in this book on constitutional amendments, making, breaking, and changing constitutions, published by Oxford University Press, 2019, what seems like ages ago now, in the old world, before the world changed. And now, as we get ready to hear from the panelists, I just want to really thank you all once again, because there's no greater gift for an author than what NUS and the Center of Asian Legal Studies and all of you have given me today, which is the gift of reading and engaging with the ideas in this book. And so I thank you so very much. I'm now going to pick up my pen and paper and begin to take notes. I look forward to our discussion. Thank you so very much.
Thank you so very much, Richard. That was a really wonderful introduction to the book. And you rightly say that the book is a kind of an intellectual map of the whole subject of constitutional amendments, but your remarks also were an incredibly helpful and interesting survey of the subject. So you've managed to pack an awful lot into just a few minutes. And if I may just offer one immediate comment, you have provided not just an intellectual map of the area, but I think you have also provided a much better and much larger map than we have ever had before on this subject. I think it really is one of those books that when you look at it, you sort of wonder, why did somebody not do this before? It fills such an obviously huge gap in our literature on constitutional amendments, and you've managed to draw all the ideas and the arguments and the possibilities together in one book. And I think that really entitles it to be called a masterwork. And I think we only have to listen to you for 10 minutes to know that even if we haven't seen the book, that this is going to be a masterwork that we're going to read. So thank you so much, but let's press on with our commentators on the book. And first of all, I'm going to ask Virginie. You have 15 minutes. If you wish to take 15 minutes, no obligation, Virginie. So we're looking forward very much to your remarks, and over to you. The floor is yours.
Thank you. Thank you, Andrew, for moderating this conference. And thank you for all of you for attending this virtual roundtable. I'm very happy to be here today, even it's 4 a.m. in Paris. And I first would like to thank CAUS and all its members for having organized this virtual roundtable. And thank you again, Professor Albert, for inviting me to my first roundtable ever as a PhD student. And I'm very happy today to present some comments with eminent panelists from all around the world. First, I would like just to introduce myself. I'm Virginie Kuoch, and I am a PhD student in Paris. I'm working on the use of foreign law, comparative law by constitutional judges in 3 Asian commons law systems, which are Singapore, Malaysia, and Hong Kong. And I also teach constitutional law, French constitutional law in Paris, and also comparative constitutional law in Sciences Po Paris. I'm very happy today to discuss Professor Albert's book on constitutional amendment, because it's not really studied in French law school or even among French scholars. Of course, we did, and we talk about during class, the French constitutional amendment introduced by Charles de Gaulle in 1962, because he used the wrong articles, which is Articles 11 of the French Constitution about referendum, to introduce the universal suffrage to elect the president of France. And this is the only time we talk about a constitutional amendment in during French constitutional class. And I really enjoyed reading Professor Albert's book, because actually it's my first time to go deeply in this theme, which I have ignored for a long time. But the strength of his book is the clarity of each chapters. Each chapters begins by concrete examples and questions which we have to ask or when we read each chapters. And the other part, what I really enjoyed in this book is the fact that it offers a journey to the four corners of the world on constitutional amendment rules. Of course, we can all comment the choices of the author about the jurisdictions he studied in his books, and those comments of choices, it's always here when we do comparative studies, because comparative studies is about choice. And here, Professor Albert's book offers a guide to everyone on different jurisdictions in this topic of constitutional amendment. He went through some jurisdictions that are understudied in comparative studies, like Kenya or Czech Republic, or even Nigeria, or even Cape Verde, which I don't know anything about this jurisdiction, these legal systems before I read his book. So it's important to have a general map about constitutional amendments in the world. But yes, of course, I can say that his books doesn't really covers, for example, Asian jurisdictions. Even talk about Taiwan, or I think South Korea as well. And yes, and that's all the Asian jurisdiction he studied. But yes, as a comparative studies, we cannot study everything, but at least he did present some jurisdictions that are understudied. I have to admit that when I thought that constitutional amendment will not be a theme that I will focus on my thesis, because I'm working on judicial reasoning, legal transplants, or even judicial dialogue. And at first, I thought that I will never study or never put anything about constitutional amendment in my thesis. That's why I'm very happy, because now, after reading his books, I know that I can put some issues related to constitutional amendment in my thesis, especially on the amendability issues, and amendability by the courts. And when I read his book, a question came to my mind, which is, in the same way that the principle of proportionality exports to the world, does the basic structure doctrine could be applied within the context of Asian jurisdictions? That's my main questions that I had, that came to my mind when I read his book. And we all know that the basic structure doctrine has been created by the Indian Supreme Court. And for my thesis, I also studied what Professor Shudri made a distinction between universalist interpretations, dialogical interpretations, and genealogical interpretations. And concerning these latter interpretations, Professor Shudri stated that the court will engage on foreign decisions, will cite foreign decisions from jurisdiction who had a historical link with the court itself. Therefore, for example, Malaysian courts will often refer to Indian decisions. And that's why I asked myself regarding constitutional amendment, if Malaysian courts did import the basic structure doctrine into their own jurisdictions. And through a contextualized institutional analysis of the Malaysian court, Professor Jacqueline Yu said that this engagement with the basic structure doctrine in Malaysia depends on the relationship between the judiciary and political powers. And she took some examples to illustrate her arguments, saying that when there are mutual respect between the courts and political powers, Malaysian courts do not hesitate to take into considerations the basic doctrine. However, when there is a constitutional crisis, like in 1988, where the relationship between the courts and political powers are strained, the doctrine is not even cited in judgment. And this came another question to my mind: would these arguments could be applied even regarding to the proportionality test as well? Because the application of proportionality test also depends on the relationship between the judiciary and the other political powers. She also, in her article, Professor New also stated that, and she cited some federal courts decisions stating that because in Malaysia there is no preamble or directive principles to define what is a basic structure, and there is no there's a lack of an exercise of constituent powers or a constitutional moment. That's why there could not be a basic structure in Malaysian legal systems. Also, as part of my thesis, I also study Singapore as well. When we study Malaysia, we automatically will study Singapore as well. And the same questions came to my mind. Does Singaporean courts apply basic structures or not? And these questions really depend, again, on the context of how did the Singaporean constitution has been written, where from who wrote the Singaporean constitutions. And in a case in 1999, the Court of Appeal said that the basic structure cannot be applied in the to our constitutions because of the difference in the making of the Indian constitutions, and our constitutions are different. And again, the question of context is put on the table regarding to the applications of the basic structures. I would like to finish my presentations with another jurisdiction I studied for my PhD, is about Hong Kong. Hong Kong legal system is so special. When we study Hong Kong legal systems, Hong Kong constitutional law, we of course study the relationship between the Hong Kong institutions, political institutions, and also the Chinese institutions, the Chinese NPCSC. And of course, in Hong Kong, we have, and as in all the majority of the constitutions, we have a article about how the basic law of Hong Kong could be amended. It is stated in Article 159, which stated that the power to propose a bill to amend this basic law shall be vested in the Standing Committee of the NPC, the National People Congress, the State Council, and also the Hong Kong administrative regions. And amendment bills from the Hong Kong Special Administrative Region shall be submitted to the NPC by the delegation of the region to the NPC's Congress after obtaining the consent of 2/3 of the deputies of the regions, to the NPCs 2/3 of all the members of the Legislative Council of the region and the Chief Executive of the regions. And as Richard Albert stated in his book, is this a provision which is too difficult to amend the constitutions here, because this Article 159 gives all details and very difficult procedure to amend the basic law from the Hong Kong administrative region's part. There's nothing about the procedure by the NPCs or even the NPCSC. And to make a difference between with Singapore and Malaysia, or even in India or Taiwan, there's a eternity clauses in the basic law of Hong Kong. And it is put inside this Article 159, which stated that no amendment to this law shall contravene the established basic policies of the People's Republic of China regarding Hong Kong. And this eternity clause, it's quite difficult to interpret, because what is the basic policies? Is it the basic structures of the Hong Kong Hong Kong legal systems, where we can find these basic policies of the People's Republic of China regarding Hong Kong. And what is interesting here, it's not the basic policies of the Hong Kong constitutional systems, but basic policies of China regarding Hong Kong. So it's like a one-way basic policies of what China considers as the basic structure, basic policies of Hong Kong. So those are the questions that came to my mind when I read Richard Albert's book. And the reading of his words allowed me to open my thesis on certain tracts of reflections that I have ignored at the beginning of my PhD journey, and I will be very delighted and excited to develop them inside my thesis. Thank you very much, everyone.
Thank you very much, Virginie, for some very, very interesting remarks, which I think really open up the discussion quite considerably. And I think it's also wonderful to have responses from younger scholars on this book, because I have a distinct feeling that this book is framing, the thoughts that you will all have as you move forward in considering this subject. And we look forward to your own original and interesting contributions in your own work to considering this. I think what we can see as this subject kind of unfolds is what I think has been referred to as a comparative turn in constitutional law. And perhaps considering the jurisdictions that you all come from and you all study, this is a very good evidence of this kind of comparative turn. And Richard's book is also a very good example of this, as you point out, Virginie, because a few decades ago, when people did comparison, they used to talk about the United States, Canada, Britain, France, Germany, and occasionally maybe India or Japan. But now we take a global view, and I think it's really amazing and also very interesting the way scholars such as Richard, he's a very notable example, are able to encompass so many issues across so many jurisdictions. And I think this is extremely important, because we are not talking about simply transfer of doctrine from kind of developed countries to less developed countries constitutionally. We're talking about issues that arise right across the world. I noticed that both Richard and Yaniv Raznai are advising on the current constitutional case in Kenya. So maybe this is more evidence of what I'm referring to here. So I think this is a really magnificent direction in which things have been going. And as you say, Virginie, the context becomes extremely important. And maybe that's something that Richard might want to respond to later on. But you've raised quite a number of really good questions. We'll leave those hanging for the moment. And no doubt, Richard, when we come back to him towards the end, we'll address these. But I want to move on with our other speakers. So I'm going to ask Sharowat, Shamin, please, if you would offer your comments now on this wonderful book. Thank you, Sharowat. The floor is yours.
Thank you so much, Andrew. This is my pleasure to be present here and to comment on Richard's book, quite popular book. And yes, I don't think that I am that much experienced or expert to critique on it, but maybe it will be wiser for me just to share my experience, what I feel, how I feel. And obviously, I would like to first thank CALS for arranging this and for inviting me into this virtual roundtable and to discuss on this very important book written by Richard Albert. first of all, starting from the name of the book, I really like when I first saw the book, the cover page that struck me, like wall has been broken, like, yeah, it is like, and the name is the Constitution, Constitutional Amendments, making, breaking, and changing the Constitution. I mean, even before, just opening up the first page, I was just thinking about my constitution. I'm from Bangladesh. I teach law at Dhaka University. I'm an assistant professor there. I was thinking, like, what happened to our constitution through various amendments. We got our first constitution in 1972, and till date we had 17 amendments, and the wall looked like I was feeling that this may be my constitution. Yeah, the amendment did exactly this thing to my constitution. It has been broken. Some fundamental structures were shattered through amendments. And yeah, so that was my first view of the book. And when I went deeper into it, it was like, I was thinking, yes, I would agree with Andrew regarding that. Yes, why didn't anyone did any in-depth research on this topic? When we talk about constitutional amendments, we mostly talk about merits or demerits of particular amendments. We talk about judicial reviews, and we talk about we bring comparative analysis, bringing about examples from other jurisdictions and comparing, like, why is this amendment necessary or whether it wasn't necessary, blah, blah, blah. But we do not ask the core question, how it was amended and how it is being codified. We miss the vital question. I mean, in the legal scholarship, such discussion was almost missing until Richard's book of constitutional amendment. So I would like to thank Richard for introducing this discussion, and I consider this book to be one of its kind, to see how amendments are made. And obviously, after reading the book, even if anyone maybe never had read constitutional law in his or her lifetime, might get help from reading this book. What is constitution? What are constitutional politics around the world? How a constitution working, or how it is being changed, how it is being amended, and why it is doing this way, why a country is going this way, and why some countries are maybe amending it in other way. So yes, obviously it is bringing about like less represented jurisdictions into these books, which is very fascinating for a reader to get, I mean, quite overall comparative analysis of various jurisdictions. But at the same time, I would agree with Virginie regarding that maybe Asian jurisdictions were less represented in this book. But maybe, yes, we are working on a book project, regarding this amendment procedure. And after publication of this project, maybe, yes, Richard, I believe that he initiated the process. And obviously, the scholarship has started and it will flow. And obviously, this idea will generate, and obviously, it has already got like, quite, the book has already become quite popular and quite well known. And as I said, one of its kind. And I would like to say that I would like to consider this book as the legal science of amendment. It is that, like, it follows the scientific approaches to amendments. And I really liked the models of constitutional amendments that Richard suggested in his very last chapter of this book. He suggested 4 models. And this is very interesting to look into, like, how a codification is being incorporated into a constitution. Probably like no intensive research was done in like only into the how question, relating the how question, how an amendment being codified. We often, I mean, in order to answer how the amendment was made, probably we used to say, like, who made the amendment, and why it was done, and what was the context of such amendment. And sometimes we discuss about the merit of it, but probably we do not question the codification process. And it's interesting to see, like, even when I started proposing for my chapter on the upcoming book, I didn't look into my constitution in this way. Like, why is a codification procedure be so important in a constitutional amendment? And when talking about this, I found that like the four model Richard suggested, appendative model, disaggregative model, invisible, and integrative model, I argued that my constitution falls within the mixture of integrative as well as invisible model. As Richard already mentioned, that integrative model is what Indian constitution is doing. I mean, the amendments are being referred in the footnote into the main text. The main original text of the constitution has been altered through the amendment, and some brackets or footnotes were inserted at the bottom of the page, in the same page. So I agree that yes, this is, I mean, the new amendments has been integrated into the original constitution, but at the same time, for instance, in Bangladesh, we have one of the core constitutional principle as secularism that was in our 1972's original constitution. This principle was amended in 1977, and it was replaced by absolute trust and faith in Almighty Allah. And after through 15th Amendment in 2011, like after a verdict from several verdicts from the Supreme Court, the Parliament amended the Constitution for 15th time, and it was tried to, I mean, the court instructed or suggested to restore the 1972's original constitution, and the Parliament in a way restored secularism in the constitution through 15th Amendment. But if you look into the current constitution, it does not show that it was in between. In 1977, I mean, another amendment was made to this constitution, which ripped off secularism from this constitution. Now you can see, like, it is invisible. You can only see that the secularism has been restored through 15th Amendment, but it misses, it omits to say in the footnote that, I mean, previously through 7th Amendment, it was ripped off. So my argument was like, whenever, even if it is the integrative model of amendment, codification of amendment, sometimes when one provision is being amended for multiple times, the intermediate amendments gets invisible. You can see only the trace of the recent amendments in the footnote, but the intermediate ones, the previous ones, get lost. So that is why I argue for that my model is probably best fit for the both integrative and invisible model. And regarding Richard's argument as to basic structure, yes, I also remain very critical about this concept of basic structure doctrine, although basic structure doctrine is very popular in our subcontinent, in South Asia. I mean, the courts love it. They love to apply basic structure doctrine, and yes, anywhere there is some, anytime they're suggesting that these are the basic structure, these are the basic structures. We got several judgments from the Supreme Court calling certain principles, certain articles as basic structures. And interestingly, through 15th Amendment, the Constitution itself added one of the provisions which says that these parts of the constitutions form the basic structure of these constitutions, which are unamendable. So yeah, that is quite interesting to see that, yes, the Constitution itself is suggesting it cannot be amended. And the same, and I mean, through the 15th Amendment, a major change was brought to the Constitution. And I mean, most of the focus was to restore 1972's original Constitution, though it could not, I mean, in full succeed to restoring procedure, because it restored secularism, but it failed to strike out state religion. In our 1972's Constitution, there was no state religion. So yeah, now it has secularism, but at the same time, it has Islam as the state religion. So yeah, in this way, maybe it sounds conflicting. And like the Constitution introduced one article saying that all these provisions are unamendable. These are the basic structure of the Constitution. The same amendment, I mean, the 15th Amendment, it introduced environmental conservation as the state responsibility. So that was quite newer idea. Like the constitutions are adopting environmental conservation mechanism into its constitutional mandate. And this amendment was brought in 2011. Probably not all the constitution still have such procedure. Maybe they have parliamentary acts, but not in the constitution in many countries. But Bangladesh constitution brought this as one of the fundamental principles of state policy, the environmental and biodiversity conservation. So, and this part, I mean, the fundamental principles part in Bangladesh constitution is unamendable, is one of the basic structure of the constitution after the 15th Amendment. So the constitution, I mean, the amendment itself is saying that you cannot change it. So what happens, like maybe in after 10 years, we will talk about like, we need a right to sustainable development. If the parliament want to add something like right to sustainable development, right to energy, how can they do that? Since this, this is like considered as this chapter is considered as basic structure and unamendable. So it cannot do that. So I do not find basic structure to be a useful one, considering the growth of the constitution, because law always changes. And Richard rightly brought about one of the Norwegian example of like striking out Jew from, curtailing all of their legal rights, which previous ancient Norwegian constitution used to have. Now they have struck off all this provision and like it got invisible. So it changed. You cannot like now introduce slavery, but it was once legal, but now it is not legal. It cannot be acceptable maybe in the modern framework. So yes, so if you cannot progress with time, a constitution cannot be developed if you like just put some principles into the box of basic structure and seal the box forever. Maybe the constitution will be stuck in certain time, but it will not time travel with us, but maybe it will just stay in the past. And at the same time, I'm very critical about, there are certain scholarships recently suggesting that whether original constitution be amended or not. And some are suggesting that some original provisions of the constitution are unamendable. I find it exactly the same thing as basic structure model. So yes, well, whatever original cannot be amended, if that was the case, probably slavery would still be legal. Probably depriving Jew of their legal right would still be legal. So yes, I believe that the constitutions need to be developed and grow through time, through modern demand. It should always be open to changes. I mean, whenever you are curtailing changes, yes, obviously it loses its scope to grow and be nurtured, be more liberal or more people-centric. Rather, maybe it would remain ancient. And sometimes you might feel that it has already time-barred. it is not suitable to present time. And the important question here, Richard asked, like, how and where the Constitution has been amended, how it is being amended. Like, he answered this question through the codification procedures, how actually the amendment is being seen in the Constitution as a text. And it is important, I mean, when I was criticizing about the basic structure doctrine, and like we used to say that the written constitutions are rigid constitutions, these are very difficult to amend. In contrast, the unwritten, it would be, I believe, that incorrect to say something unwritten, as we used to call UK British Constitution as unwritten, but probably it will be more appropriate to call it uncodified constitution, because it is written somewhere through parliamentary acts. It's not solely unwritten, but probably it's just uncodified as a single text. So when we look into the question of how the amendment was made, and like whether it is a flexible way of amendment or a rigid way of amendment, we used to say like our constitution is rigid because it requires two-third majority of parliamentarians vote in order to amend one of the provisions of the constitution. But if you look into the current trend, I mean, if a parliament is overwhelmed with more than two-third majority of the ruling party member, is it very difficult to amend a particular constitution, a particular provision? Or even it is maybe possible to adopt a new constitution. So yes, whenever the constitution itself is introducing basic structure, and at the same time in practice, we see that the parliament is having the ruling party with more than two-third majority, the whole question of flexibility or rigidity of amendability becomes problematic, I believe. Yes, and this book brings about a whole lot of issues of constitutional amendments. Not only, I mean, the models Richard suggested, I mean, these 4 models, these probably are regarding only the codification issues, I mean, how amendment is being codifying in the Constitution, but it also suggested all aspects. It addressed almost every aspect.
Can you please wrap up, because we're getting really way behind time.
Just one more minute.
If you wouldn't mind, thank you so much.
Yeah, no problem. Yeah, so yeah, I'm just coming to end. In one word, I would say that this book is the science of amendment. This has established as legal science of amendment, and obviously we will see in the coming years maybe Richard's ideas and theories will be reflected in many other scholarly contributions in future, which will prove its success. I believe it will be a success. Thank you so much for inviting me. Thank you, Richard, for writing this book.
And thank you, Sharowat, for some very wide-ranging and very challenging and very interesting remarks and also questions. I don't want to sort of embark on trying to summarize or pick too much out of what you said. We'll leave that to Richard to decide. But I do think it's very interesting the way you have related this whole discussion to the idea of codification and the question which Richard himself raised in his opening remarks: what really counts as a constitutional amendment? We obviously don't take a formalistic view that whatever calls itself a constitutional amendment is a constitutional amendment, because as you've indicated, there may be other ways of amending a constitution, and there may be things that we don't want to count as a constitutional amendment, even if they pronounce themselves as so being. And I think also this idea of the basic structure and how that relates to the concept of development, to sort of capture a number of issues in one word from your remarks. I've actually myself also recently written on the question of the relationship between constitutionalism and development. So in this formulation, you know, the constitution is maybe not to be seen as a kind of a ancient fixed set of rules, you know, that deals with what it deals with, and everything else is somebody else's problem. We now try to see what, when we are codifying, what is it exactly that we codify or we should codify in a constitution. You mentioned the environment, and notice here that in Bhutan they have a constitutional rule that says there must always be 70% forest cover. Now that's a very original thing to put in a constitution. And I recall at some point in the past a survey was done in Poland on what constitutional rights should be included in the constitution, and you know, the most popular one was the right to heating. Have you ever seen the right to heating in a constitution? Well, you know, these are kind of new ideas that we should be thinking about. And thank you so much for opening up the discussion. But we are a bit behind, so I want to call on Khemthong to offer his remarks on this wonderful book. Khemthong, over to you.
Thank you very much, Andrew. I have a copy with me, so I check it out from the library. All right, but yes, this book is very much like Richard Albert himself. I mean, he is generous, meticulous, and comprehensive, and this book is really like very generous in the range and coverage of the book, very comprehensive, and yes, very meticulous too. It can be read almost as if a guideline or best practice if anyone want to amend a constitution. So my talk here today will be, please consider it to be a regional reflection on the book. So I am not trying to lecture about Thai constitutional change, although there's a lot to be said about, but it's a reflection on the contribution of Richard's book, how the book's power to explain, to justify, and also to offer some solutions to Thailand's current political conflict. So I think I will start with 2016. It was after the constitutional referendum. We were then 4 years into the military dictatorship, and somehow the military offered us a constitution, and in a very sham referendum, about 51% of Thais vote in approval of the draft. But then King Chulalongkorn said that he wants some change to the constitution, and the junta amend the interim charter to give them the right to amend the draft before its promulgation. I'm not sure if this is count as amendment. This is a very extraordinary amendment because the draft was amended before it was enacted. But it brings, the episode brings a very big question of why the amendment matters. I mean, it asks one of the most fundamental question about the constitution, which is who is the sovereign? The one who has the right to amend the constitution must be the sovereign. I mean, that puzzles a lot of Thais. I mean, of course, I mean, the people are not the sovereign back then. I mean, even now. And we think that the junta is the sovereign, but then the king asked for an amendment and the junta comply or obey. So that's one big question about constitutional amendment and why it matters. I mean, Thailand is a constitutional graveyard. We have at least 20 constitutions already, and we are counting to get some more in the future too. But so amendment is often an afterthought because no one thinks that the chapter gonna be invoked at all. I mean, all the change come from military junta, from tanks and guns. So usually amendment procedures or amendment rules is often just simply a glorified legislative procedure. So you get supermajority, but nothing, not much thought is put into designing the amendment rules. But that start to change since 2007. There's a call for constitutional change via a more peaceful channel through an amendment. So there's a period in Thai constitutional history. So that's 2012, and just earlier this year, 2021, that we try to amend the constitution to rectify the wrong. People say that, and both times we spectacularly failed. I mean, we just like failed. But that's I will go into detail. But first, this is what I want to highlight about contribution of Richard's book on the situation. It explains why it failed and justification for the people's call for amendment. So in both episodes in 2012 and earlier this year, the call for amendment was were a reaction to the 2006 and 2014 coup d'etats that produced the 2007 and 2017 constitutions. So the call for amendment both times are actually about the identity of the constitution. So the people want to change or to amend the identity of the constitution. They want something completely new. They don't want something technical or functional. They want to completely erase the history of the coup and rewrite their own episode. So you can see that that is not a normal amendment that we usually consider of. I mean, it and the court intervened, saying that you cannot do that because the primary original constituent power is set, and any amendment couldn't exceed that primary power or the original intent of the constitution. And so in both times, the court said that it was unamendable, or at least it needs some special provision. But that posed a very big question to a lot of Thai people, that, I mean, so you cannot improve the quality of democracy. You cannot build something better and quite rather different upon the old constitution. Is that like constitutional revolution is the only way to go? And that's people has been pondering this for a big while. That but if you see, following Richard Albert's dichotomy identification of types of amendment, you see that no, actually you don't have to go that way. I mean, radically changing it through a revolution or popular uprisings. If you understand the concept of dismemberment, you see exactly this is what Thai people trying to do with the 2007 and 2017 constitution, that you try to dismember the old one and you try to create something new on top of it, but trying to retain the form, the format, I mean, as a constitution, the same constitution, and continue it so on. I mean that's practical and that's advisable, because I mean, bringing constitutional change through a revolution is not an easy task, and I mean there's not a regular path, and it can lead to a lot of unexpected twists and turns that no one can predict, right? So that's my first point. That's that, I mean, the book can justify and explain the people's call for amendment as something rather different, still an amendment, but and it's justifiable. But then, as I said earlier, the constitutional courts intervene both times, saying that this is not a normal amendment and you need a special. First, the court said that you need a referendum, and then the court go on in subsequent cases saying that but you cannot amend a certain chapter of the constitution about the electoral system and other powers. So I am not trying to read too much and try to give the court too much credit that the court understand dismemberment. This is a caveat in my story that the constitutional court's reasoning may be less genuine and it might match what we understand now as an abusive constitutional borrowing. So the court just borrowed the basic structure doctrine and the court borrowed the idea of constituent power and try to twist it in order to entrench an undemocratic structure of the constitution and say that no matter what, you couldn't pass that. I mean, it is quite obvious that the court tried to invent some extra amendment procedures like a referendum of in order to obstruct the people's call for amendment. Because in 2007, as I say, in 2007, the amendment rule is just a glorified legislative procedures, and the court invent a referendum in order to block the attempt, and the court further elaborate that, but certain part cannot be amended. In 2017, the drafter was designing a new amendment rules, and there are certain tiers that if you try to amend certain chapter of the constitution, you need a referendum. But then again, the court said that no, you need 2 referendums before and after the amendments. So the court keep raising the bars, the cost of amending. So there's a caveat in my story. I mean, about borrowing the idea of replacement, the idea of dismemberment to entrench an undemocratic constitution. Now I want to address the second contribution of Richard Albert's book to this story. I mean, the root of all this struggle and obstacle is something of the idea of rigidity of the constitution and the rigidity of an amendment rules. As I said, Thailand is a constitutional graveyard, and the first reaction to any attempt to amend the constitution is no, is a rejection. No, we don't want to amend it. Because we try to make something that lasts really long. So any change to it is a bad thing. So the constitution has to be as it was written, as it was adopted. You cannot amend it. And I would say that among a lot of constitutional scholars here is almost like a fanatical belief that you have that the more rigid the rule is, the better it is to protect the constitution. But if you look at the relationship between rigidity and democracy and amendment in Richard Albert's books, you start seeing clearly that no, sometimes more rigidity is not always a virtue. I mean, it doesn't allow a peaceful change that might be in accordance to changing demography and changing circumstance over generations, over time, and that's something that that I think there's a great use of Richard Albert's book when you read into Thailand's history of constitutional amendment. First, I mean, you have to understand that this is not normal amendments. There's a few amendments that are technical, just like purely technical things that has been adopted. But you see that why there's a clash, there's a block here. And if you understand about dismemberment, you understand what is happening. And the second thing is, if you are about to talk about solution, the way out of this conflict, I mean, first thing first, you have to change your perception about rigidity and the link to democracy. So in all that's my comment or reflection on Richard Albert's book from my perspective, from my own research project. Thank you very much, everyone.
And thank you, Khemthong, for again some very, very interesting remarks. And I was wondering at the beginning of your remarks whether whether we shouldn't also be addressing Richard's book on revolutionary constitutionalism, because you know, much of the earlier part of what you said seemed to have some kind of relationship with that book. So Richard, unfortunately, is writing books faster than we can actually provide, you know, roundtables discussing them. So we'll have to try and catch up with you, Richard. You're just too prolific. We can't keep up. But Khemthong has raised some really interesting questions. I mean, when you consider the context, as we have been saying we need to do in looking at these issues across so many different countries, I mean, I start to wonder whether constitutional dismemberment might actually be quite a good thing and not the bad thing that Richard told us it was at the beginning. It rather depends what kind of a constitution you are trying to preserve or trying to dismember. So maybe there is some merit, and that kind of, to me, raises also another issue that Richard referred to, which is the basic values on which the Constitution is being based. And of course, in some instances, you will have a preamble that tells you what those basic values are. But in most instances, we have nothing to guide us. And this kind of leaves open the possibility of this kind of sleight of hand constitutional amendment, you know, abusive constitutional amendments, backsliding constitutional amendments. And one of our questioners is even talking about, you know, dictatorship, as you have kind of referred to in this context. So I think this discussion is extremely interesting, but time is, you know, is rapidly running out. And I want to give Richard an opportunity to respond, but we've also got some questions from the floor. I think the first one actually just repeats what you already said about dismemberment. So I will pass over that one. But Leonardo has raised, if I can just briefly summarize this, I mean, a couple of sort of really interesting questions. I mean, one is about translating the book, and you know, maybe we can frame it in this way to Richard. Do you have any thoughts about the fact, you know, that work of the kind that you are producing and others are producing seems to be always written in English, and that might be a problem for people who want to read it in, you know, Chinese or Portuguese or whatever other language, and we don't seem to have a mechanism for that. So I think there is an issue about communication, which you might want to say something about. But the second point, perhaps even, you know, more important than that, because Leonardo is raising, I think, a very important question. And let me sort of try, you know, I hope I'm reflecting the question properly here, to sort of reformulate what is quite a long question, to put it this way, that he's concerned about the issue of dictatorship and the fact that this can happen through different means. The Constitution is not necessarily going to prevent dictatorship. And so we try to deal with this through our ordinary laws and through our, you know, constitutional conventions would be relevant in many countries. But this is kind of a fragile way of protecting the state against dictatorship. So I wonder if you had any thoughts about the fact that so much of what we depend on constitutionally is actually just entrenched in the ordinary law, and therefore is not even a matter for constitutional amendment. It can just be changed, or it may not even be contained in the law. It may be just contained in people's understanding and idea of what is the right thing to do in a given situation. So how do we deal with that in terms of constitutional amendment is, I think, a very interesting point. And then Damien also raises an issue about constitutional amendment via judicial interpretation. So this is kind of another aspect of the kind of non-formal part of discussion of constitutional amendment. So I hope that isn't, you know, too broad or challenging a range of issues, but you know, if you could address at least some of that, and of course the questions that have been raised from our speakers, that would be that would be really great. I'm sorry time is quite short to do that, Richard, but thank you.
Well, thank you very much. And what I'll do is I'll just hit on a couple of ideas, and then if the panelists wish to join in, please do so. But thank you to Prapreet and Leonardo and Damien for those questions. Thank you to the panelists for those really fabulous comments you've gave me and shared with me. I've been taking notes. Perhaps it'll be a second edition of the book or a paper to follow. And Andrew, thanks to you for interspersing your own thoughts and contributions to the discussion in between each of the speakers. I should say that the work that I'm doing, that others are doing, we're building on much of the work that Andrew has really inspired. As you all likely know, the Constitutions of the World series is Andrew's baby. And this was one of the big steps to open the world and the richness of the world to those of us who read English. I read English, French, other languages, but my primary language of scholarship is in English. And so this really opened up parts of the world to me and others. And that really built the field of comparisons, constitutional comparisons. So we want to thank and acknowledge Andrew for all the work that he's done in that regard. And insofar as there's a lot of room now to learn about the judicial review of constitutional amendments in Asia, constitutional amendment and dismemberment in Asia. These questions are fascinating, and both Sharowat and Virginie, both of you are right when you suggest, and in fact, I think assert correctly, that the book could have covered more ground in Asia. But I'm so pleased to see new books coming out that do focus on Asia and raise these and other questions. One that's coming to mind in particular is a book to which Andrew and I have both contributed, edited by Rehan Abiratne and Nok Son Bui, on the politics of the unconstitutional amendment doctrine in Asia. And so I recommend that book. So it's just really great to see scholars taking the baton from persons like Andrew and sharing the knowledge rooted in Asia about the Asian experience on these questions. Just a very short few remarks on the points raised to me. Constitutional dismemberment is a neutral concept. We can use the concept to refer, for example, to the dismemberment of the Hungarian constitution from liberal to illiberal, just as we can use the concept to speak of the reconstruction of the United States Constitution from slavocratic to democratic. And so the idea is simply a major change, a transformative change that does violence to the existing Constitution, whether good or bad. And so I want to really stress that it's a neutral concept that can have that application. There were a few other questions, and I want to just hit on them very quickly. The translation, Leonardo, that'd be a great idea. I'd love for the book to be translated into Portuguese. If you have suggestions for that, please do let me know. I know the book is being translated into Spanish. I would love for it to be translated into French. It is also being translated into Bahasa, Indonesian, and some of the chapters I think are being translated into Russian. But it'd be great if anyone has suggestions for other partners. Just please let me know. I'd love to learn more about how we can get it translated. On the question of dictatorship, this fascinating, important question, one of the most pressing questions of our time, that the challenges that constitutional democracy is facing really aren't the kinds of challenges that the rules of amendment can guard against, right? Because either those who want to disassemble the apparatus of democracy can win control of the amending actors, whether they're the parliaments or the presidency or even the courts. They can get control of those things. And so when you create a constitutional structure, you have to be aware that the structure itself is not going to protect democracy, right? That has to come from somewhere else. So whether you make a rule unamendable, as we see in the Czech Republic, where the democratic character of the state shall be unamendable, that's not going to protect democracy. Unamendable, it won't protect democracy. Where you have a court either authorized to or that has asserted the power to invalidate an amendment. That's not going to protect democracy. Where you have a constitution that is very hard to amend, that's not going to protect democracy either. And so we have to look elsewhere for these protections for the values that we care about. And I think the bottom line, really, two things. One is that constitutional structure cannot control, cannot direct political culture, right? Constitutional structure is really powerless to do that. Second, the values that we care about, the democratic values that we care about, they rely on a measure of forbearance between and among political actors, and a shared understanding of what is appropriate, what is proper, what is permissible in a democracy. And so that, I think, is where we have to look. Rules written down on paper can help. They can help by signaling what is proper behavior, what is proper conduct. They can help by serving as speed bumps, but they cannot stop an autocrat or an autocratic leaning leader backed by a party and an apparatus from achieving their autocratic designs. Just one final thought in response to Damien's question. Damien had a question about whether it's possible to think of a judicial amendment to the Constitution. So when a court makes a decision that has a dramatic impact on the Constitution, can we think of that as an amendment to the Constitution, a judicial amendment? And here I think the answer is yes. And let me give you just three very short examples from different parts of the world. One from the US, one from St. Lucia in the Caribbean, and one from India. So the US case of Brown versus Board of Education, which overrules Plessy versus Ferguson, I want to define that as a judicial amendment, because what's happening is that there's a repudiation of an existing rule in the Constitution, which is that segregation is permissible, repudiated by a new rule introduced by the court, consistent with the Constitution, however, the written Constitution, the 14th Amendment. That's not a dismemberment of the US Constitution, because the fundamental protection that the court is vindicating in Brown versus Board appears in the Constitution already. So it's an elaboration of an existing rule, but nonetheless an amendment of the Constitution, in my view, judicial amendment. St. Lucia also gives us an example of an amendment by the court of the Constitution. The St. Lucian Constitution had a typo in it, typographical error. And there was a lot riding on that typographical error. And so the court said, we're going to read the Constitution, reread it in the proper way without the typo. That's a judicial amendment to the Constitution. And then third, a case from India. This is the NJAC case, where the court actually enforces a constitutional convention about the independence of judges in the appointment of justices to the Supreme Court of India. That must be understood as a judicial amendment to the Constitution, if only because you have a court enforcing a convention. That doesn't often happen in courts around the world. That's a dramatic moment, but it's not a dismemberment of the Constitution. It's, in my view, still an amendment, judicial amendment of the Constitution. Andrew, I'll just take 60 seconds just to say thank you to Virginie for pressing me to think more about Asian jurisdictions and how the basic structure doctrine is applied there, to think about Article 159, about rigidity. That's a very important point of reference for me, because I'm writing right now about constitutional rigidity. So that'll be useful to me. And of course, Charles de Gaulle and his 1962 amendment, fascinating, always gives us something to think about. Sharowat, thank you for your reflections on the cover photo and how that is evocative for you of the Constitution of Bangladesh and the pressures that it has come under in the past 50 years. Really fascinating. A broken constitution, broken by amendment. I will come back to this example. And thanks also for asking the question whether an original constitutional rule can be unconstitutional. In fact, I'm writing a paper right now, Sharowat, with someone from Bangladesh on this question, Ridwan. If you know Ridwanul, yes, I'm writing with him on this question, whether an original constitutional provision can be unconstitutional. Fascinating question. And thanks also for your work on models of codification. And Khem, thank you so much there that, I would really like to learn more about the Thai case, because it seems like there is an explanatory potential there for the ideas of dismemberment and the sequences that you've traced from 2007 to 12, then 2016, 17 to 2021. I think there's a great, I think there's capacity there for helping to explain what's happening in Thailand, but also to explain to the world with reference to the idea of dismemberment and also constitutional design. Very, very important. And so I'd like to chat with you more about this, all of you more about these ideas separately, so I can do some more work and put these ideas down in paper, perhaps in collaboration. If any of you are interested, I would love to think about working together on these. And so I don't know if, Andrew, I've spoken much longer than you had thought I would. I apologize for that. But you see, it's been such a gift to have the benefit, all of your advice, all of your reactions and your ideas. Thank you so very much to each of you, not only the panelists, of course, our moderator, and the questions from the floor. Thank you so much.
Thank you, Richard. The gift has been to us, and it's been absolutely great to have you here. And I think you've had some wonderful responses, as you said, from our three speakers. I think I can't recall a seminar in which so much has been packed into an hour and a half of discussion. And obviously we could and we would love to go on very much longer talking about this book and its implications and all the issues to which it's given rise. Just finally to offer, if I may, personal reflection. My first ever academic article was written on constitutional amendments on the basic structure doctrine back in, I think, 1979 or 1980. And I recall spending most of that year, it seemed, reading Keshvananda Bharati, which is still a fantastic introduction to the whole idea of constitutional amendments. And we could spend a seminar just talking about that particular case. And as you've noted, there are other publications. There's this new one coming out, edited by Rehan and Bui, which will be extremely interesting for this discussion. And of course, Yaniv Rosnai's wonderful book on unconstitutional constitutional amendments. So for those of you watching and listening to all this, you've had an absolute treat and an absolute education in this subject. Constitutional amendments are eternally fascinating, and Virginie, just to comment on what you said, I said in my original article 40 years ago that it was uncertain whether basic structure doctrine applied in Malaysia, but it should be applied. And the position now is exactly the same. It's still uncertain whether it applies, and I still believe that it should be applied in that context. So some things don't change. But Richard, thank you again so much. You've opened up so much that is fascinating and important and really, really interesting. And thanks to those of you who raised questions as well. But unfortunately, we will have to bring it to a close. But I think there is no doubt that we must do this again with your later book on revolutionary constitutionalism. So thanks to Suguna and Ernie and everybody at CALS. Thanks to our speakers. And we hope it's not too late at night for you over there in Ottawa, Richard, but it's been absolutely great, and we look forward to welcoming you again. So we'll have to, unfortunately, close it down at this point. And thank you, by the way, for your personal remarks as well. It's very kind of you.